Okay, thank you all for being here today, and let's go ahead and get moving. We're at the Greater San Diego Association of Realtors, and thank you all. I'm honored that you would take your time out of your day to attend this webinar. I promise you that it'll be very informative. Our goal here is to go over some of the issues that I deal with in trial, as well as some of the things that I teach. So at least for purposes of how to read a preliminary title report, which is what we're here to do today. So I'm going to go over some stuff today, and it's going to be relevant in a lot of different ways, but my job is not to scare you. My job is just to inform you, and so hopefully you will take it that way. And let's learn something new, okay? And so 41 years plus in this business. When did I get my license? 77. And still learning something new every day. So hopefully that happens to you as well. I am not a practicing attorney. I am not interested. I make more money than most attorneys that I know, and so should you. At the end of the day, we're going to talk about stuff that's going to sound legal, but I am teaching continuing education for attorneys tomorrow night again at UCSD. So MCLE approved credit class, and when I teach this class, in that class, it's goes in a different direction. So, but it's definitely going to be a good one for us today. So I do a lot of trial work, mostly defending real estate brokers, standard of care, market conditions, agents' duties of disclosure, et cetera, et cetera. What we talk about today is not intended to be a substitute for the advice of your broker. Listen, if your broker tells you something, do it. Okay, you hired them. They're there to help you. And so make sure you take the advice of your broker, make sure you take the advice of your attorney. If I say something that you need more clarification about, please send me an email. More than happy to take that from you, and happy to help in any way that I can. I made a comment yesterday in our listing input program, you know, that here for example purposes, we're going to take we're going to pay 10% commission to the other side. And so, you know, the whole point behind the 10% was that there is no customary, ordinary, usual. Everybody does it. They won't show your property if you don't pay it. There is none of that. So, you know, my whole comment there was intended to tell everybody that, you know, it's whatever you want it to be. And that was the whole point. So got some really good questions about that. It was a good interaction. So today, if you want to get on my email list, I do have one. I don't add people to it automatically. They have to ask. I'm almost embarrassed to say sometimes they have to ask twice, but I'll get you on there. You got to send me an email, kevin@burkerealestateconsultants.com, and I am more than happy to put you on my list, and you will get an email one time per week. If I make a mistake, I'll send it a second time, but that's only happened once in history. So, and here I am today. Okay, so that's kind of what we're going to talk about today. Let's go ahead and launch into our subject matter, because I'm really excited to talk about this stuff. This is good stuff. So here I'm going to open up our, thank you to Fidelity Title, by the way. They were kind enough to give me a sample report, and something that I can use at least as a tool to explain to you what's going on in a preliminary title report. So we've got some really big court cases out there. We have the Field versus Century 21 Cloud and Furness case. Let me make sure you can all see the screen. I am more than happy to send this to you if you want a copy of this case. In fact, I back that up. We're going to send it to you automatically. Just because you're here today, we're going to send you this case. Okay, so you're going to see the actual case. It was a winner, right? I mean, it was just not good for us as real estate agents, but the outcome of it was that it wasn't what people think it is. It wasn't necessarily that the agent didn't explain the prelim to the client, but more so a statute of limitations case. But in the dicta, the judges held that the agent should have been more diligent about this. The title report in that case wasn't even delivered to the parties until after closing. So there were a lot of really bad things that happened in that situation. So anyway, great case. I think you should read it. I assign it to my attorneys. They've got this one. I think I signed this last night. So they've got this case to review already, and I'm not going to give them the actual case. They're going to have to look it up themselves. Another really big case for us is the Easton case. And the Easton case has to do with our obligation to do a reasonably competent, diligent visual inspection of the property. So again, I'm going to send both of these to you just for being here today, because I think they're both really interesting and you can read them, and hopefully it helps you to be a better real estate agent, which is kind of our goal, right? We want to get good at what we do. Okay, and so somebody yesterday sent me this email and said how passionate I was. I am passionate. Listen, I love real estate. I have never had so much fun in my life. It's nice having this as a second career, right? So it's like, I only got it back, when I was younger. But I'm going to tell you something. You should be having a lot of fun in this business, and I don't want you worrying about things. I want you to just be educated, okay? So let's talk about that preliminary title report. So there is no law that requires a preliminary title report. There is no law that requires title insurance in California. There's no such law. But the problem is the courts have held that, when you didn't get it, that it was easy to obtain, readily available, fairly inexpensive, all of this stuff. And this all came out of a court case, by the way, all this stuff that said, why do you just get it? So, some people will argue with me. They'll say, well, there is a requirement. The law does require it. Every transaction I've done. Well, every transaction that you do that has a lender involved in it, the lender says, I want a copy of the title policy. And I also want to know that I've got coverage, for my loan amount, not necessarily for the purchase price of the property, but for the loan amount. And so that's what's really going on here. Okay. So, so be aware that, again, and the lender's telling you, we think it's a really good idea. The ones that slip by us are the cash transactions where the agent maybe, or the parties just do. I have one right now where there's the buyer hands the seller $200,000 in cash to buy their property and has no escrow, no title, no real estate agent. It's gone, right? It's gone. And so good luck. You're going to be chasing this guy for a long time. And what a shame. I don't know about you, $200,000. It takes me a couple of weeks to earn that. And so, I'd like to know that it's in safe hands, but handing over your money to a complete stranger, I don't know where we're getting that from, but okay, fine. I'm going to start selling my house for that. Okay, so let's talk about our preliminary report. So I want you to remember that it is a preliminary report, which means it is preliminary to actually getting an insurance policy. So you don't sue on this. The lawsuit comes after the recordation, after transfer of title. This is preliminary to it, okay? So this is not an insurance policy. This is an offer to provide an insurance policy. And that's the really important part of all of this, okay? So it is an offer to provide a policy. It is not the actual policy, but we have to read it like it is the actual policy, okay? Because that's going to be important. Now we're going to have this part of it, and then we're going to have another part of it, close to closing, where we might get a supplemental report. Excuse me just a second. That COVID-19 thing. So, there's just kidding, no COVID-19. And you can't get it through the monitor. But now I lost my train of thought. So anyway, as the phone rings off, I'll look over here. Okay, so that being said, it is a preliminary title policy, preliminary to issuing a title policy. It is not a title insurance policy as it stands. Okay, so this on the first page are all the admonitions you get. You're going to find most of these are alike. You're going to find that they all talk to each other. All the different companies work with each other. They underwrite each other. They have all this stuff going on. There's Chicago, there's Fidelity, there's First American. There's all these different insurance, title insurance companies offering title insurance. Remember that the alternative to title insurance in California would be what we see in some other states, which is an attorney's opinion of title. And so that's going to be, when you have a problem with that type of insurance, or that type of policy where it's the attorney's opinion, then you sue the attorney on their malpractice insurance versus title insurance. You just sue on the title insurance policy itself. So I've been doing this for a long time. I can tell you I have had one claim against title in all of my years, and I'm doing well over 100 transactions a year. And I can tell you I had a claim back in 1984, which had to do with a second deed of trust on a property. It was a 3.3 acre parcel of land, and it had a mobile home on it, and there was a first and then apparently an unrecorded second. And then it turned out there's all kinds of fraud and stuff involved in it. And ultimately, a title insurance company paid the second off, took the property back, and then went after the parties that were involved in the fraud. So now I wasn't involved in it at all, of course, but it was an interesting experience. But that was 1984, folks. I mean, that was 35 years ago, 36 years ago. So you're rarely ever going to have a claim against insurance, but when you have, it's a doozy. Okay. All right. So this is in response to asking for a policy here that we're going to have exceptions and exclusions, and we're going to talk about the difference between those two. Okay. Exceptions mean these are things we're not going to insure against, but then the exclusions are these are things that we never insure against. Okay. All right. Report and any supplements or amendments is intended solely for the purpose of facilitating the issuance of a policy of title insurance, and they have no liability up until after that happens. Okay. And in fact, you can tell your buyer that, they'll get their certificate of title insurance that have a great big pretty little symbol on the front and everything. They'll get that about 30 days after the transaction has occurred, after it has been fully executed. I love that. I get this all the time from transaction coordinators. In the middle of a transaction, I'll get an email that says, here's the FE contract. And I go, what's FE mean? And they go, fully executed. And I go, no, it's not fully executed. It's an executory contract until such time as it closes, and then it's fully executed. So let's be careful about the terms of art that we use in the legal field, very different than in the real estate field. And sometimes we think things sound really cool, and so we go ahead and use them. So let's watch out for that, okay? Linda and I have a big joke, a big laugh about that. Okay. So here's your policy, here's your counter signature, here's all this stuff, okay? So moving along, I got to move a little quicker here because it's funny how an hour to do this is just not enough. I will spend 3.5 hours on this tomorrow evening when I'm doing the title for the law class. So here is the company again. Thank you again to Fidelity for providing this preliminary title report. I'm going to have a couple of key pieces of information on page 1, and that's going to be who is the escrow officer that's handling it. It may or may not be Fidelity Escrow, because in Southern California, at least, we do things where we bifurcate the escrow and the title as two separate companies. I just closed one that escrow and title were the same company. It's just whatever you're going to get, but you've got choices here. So escrow officer's name, the order number of the policy, the title officer's name. So questions that need to be directed, if you have questions about a preliminary title report that you've got going on, you need to call the title officer, okay, not the title rep. And listen, okay, we love the title rep. They're really nice. Can't buy us donuts anymore or give us flags or Thomas Brothers or anything like that. The person that's really going to be knowledgeable about it is going to be my title officer, okay? And I have no problems calling the title officer directly. I have no problems doing that, okay? And you should. And you should direct your client to doing that if it's something that your client has a question about that you're not able to pretty quickly get an answer to. Remember, you want to be the source of the source, not the source. Hi, Patricia, hand up, question. Patricia, write it in the Q&A, okay? Would you? And then I can take a look at it. Wowee, thank you all for being here. This is quite, hey, Don, welcome back. Homer, hi, buddy. You got quite the crowd today. Yeah, you think it's a good thing I'm not afraid of public speaking, right? Okay, all right, Patricia, write me a question, okay, hon? Right there in the Q&A part of things. Okay, so the title officer is the go-to person for title, and that's the person that can answer any questions that you might have about the title policy. Everybody else you talk to is going to hem and haw and all that. Listen, when people start hemming and hawing about stuff, you want to go, you know what, I need to go straight to the source. Okay, so who? Reliable escrow company, here's the address. So in other words, the escrow company orders it normally for the parties in the transaction. And so now the title company is going to send it to this escrow company. Attention to Jane in this case. The reference number is going to be this 737. Notice it's a different number than the order number, okay? So her reference number will be her escrow number, okay? Property address. Now, I want to remind you that the property address, and this is in most every state I teach in the United States, but the property address is really more of an accommodation. It is not the legal description of the property. We're going to see the legal description in a minute, but this is an accommodation. This is intended to create something that we can all reference. And remember, when we're creating contracts, we want to be able to reference certain parts of the contract, okay? And so you and I will see it as 2536 Brandywine Avenue versus the legal description will be something that's much more complicated, and it could be meets and bounds. It can be a lot of different things, okay? Patricia, question, right? Q&A. Click on Q&A. Okay, so the effective date, here is the effective date. It's usually really early in the morning, okay, and it's usually right like today, even though I'm not closing for a month, it'll have like today's date. So effective as of this date, here's what we're contemplating doing for our title insurance, okay? So the form being contemplated is my Alta Homeowners Policy of Title Insurance. I would recommend that over California Land Title Association, a CLTA policy, only because it contains more coverages. It also covers some items that are not recorded. Now, I don't have an insurance license either, so I can't really give you insurance advice. And remember, this is an insurance policy. So remember to take that into account when you're speaking with your client about it. That's why I tell you to be the source of the source, not the source. Send them to the source of information so they can get it firsthand, okay? And then that way there's no third party telling a story as we go along that may change the outcome of their question, okay? So we're also, secondly, we're gonna have an Alta loan policy. And as I mentioned earlier, that is the policy that covers the lender's interest in the property. So usually the lender's interest, it's $1 million home and it's an 80% loan to value. The lender's got 800,000 in it. And so they need a policy that's for 800,000. Normally the buyer pays for that policy, okay, normally, all right? But that's just our contract says that. So number one, estate or interest in the land, hereinafter described, is a fee. And remember, fee is the highest form of estate, highest form of ownership of property. And by the way, people will ask you questions like, how should I take title to property, things like that. And you can't really answer that because it has legal and tax consequences, but your friendly neighborhood title rep can probably get you a chart that shows you the different ways of taking title. And you can give that to the client because it's been vetted by by the lawyers at the insurance company and all that, okay? Everybody good with that? It's pretty helpful. There's a lot of stuff they can do. They're all going to fall back on Senate Bill 133 and say, I can't do anything. And that's not true necessarily. They just have to offer what they offer you. They have to offer everybody, and they can't charge for it, okay? All right. Okay, so paragraph within number 2, here's how title is currently being held. It's currently vested in seller person and Mr. Robert and Mary, husband and wife as joint tenants. Again, don't get into the dialogue about what that means because you don't, unless you're a lawyer, I wouldn't be explaining joint tenancy. Okay, as to an undivided half interest, and then John Doe as trustee of a trust as to the other half interest. So in this case, I have husband and wife half interest, and then I have John Doe, the trustee for the other half. Okay, number 3, land referred to in this report situated city of Chula Vista. Gee, how coincidental! Out of Otay Mesa came the case, the field case. The city of Otay Mesa. It was a great case. Most any attorney you speak with is going to say bad law, right? But again, 9th Circuit decision, and we're just going to have to live with it, okay? But that came out of Otay Mesa. All right, so all the best lawsuits happen in Southern California. I got to tell you, it's great stuff. Okay, all right, so Chula Vista, and is described as follows. See Exhibit 1 attached and made a part hereof. And let's go ahead and move down. Here's Exhibit 1, and this discusses what the property, so now when I look at this, isn't this a lot, wasn't it a lot easier to just put the address on Brandywine? Can you imagine having to put all this in your contract, in your purchase agreement between the parties, or in your listing agreement, or anything like that? This is much more complicated. This is going to nail the property down to this stamp right here versus the street address that the post office understands it to be, okay? But the key piece of information in here is I got my assessor's parcel number. Now I have what we refer to as our APN number, which is essentially the thumbprint of the property, okay? All right, let's move along here, and we're going to go questions so far. I guess I lost Patricia on that. Sorry, Patricia. Get back to me if you have a question. Okay, so let's take a look. Oh, God. Wow, this is, I got a fast internet. It is still slow. Here's my order number up here again. That kind of looks different than the one that was on page 1, but okay. Attention to detail is really important, right, Dottie? Okay, at the date hereof, which was the date of the report, okay, items to be considered and exceptions to coverage are going to be X, here they are, will not pay attorney's fees and all that kind of stuff. Taxes and assessments, which are not shown as existing liens. Now they are, right? There's always going to be a tax on all property, and there's almost always going to be a supplemental tax as well, okay? But this is explaining what they're going to pay on and what they're going to work around, okay? Any facts, rights, interest that are not shown by the public record, right? Because, you know, they can't know what they can't know. You know, you have an obligation. Remember that in rem jurisdiction thing that says that it's where the, oh, maybe I did that in that law class. Anyway, the in rem jurisdiction says where the property is situated. And so in this case, you know, you're supposed to, if you have a recording or anything against a property, you have to record it in the county where the property is. But if it's not, then that's the place for public notice. And if you don't put your notice in there, you know, you have a judgment or something like that, then how are they going to know? Okay, so they're going to not, you know, they don't want to be held liable for something they just can't possibly know. All right, easements, liens, encumbrances, claims. You know, these are the things that I talk about in the law class. Easement is just a right to use the property of another. A lien or an encumbrance can be a loan. It can be, you know, some other interest in a property that might not be shown by the public records. Discrepancies, conflicts, and boundary lines. They don't want to be responsible for that. They don't, excuse me, they don't want to be responsible for unpatented mining claims or any of this other happy stuff. Liens for services, so like a mechanic's lien, and then property taxes, liens not yet due and payable, including any assessments. You know, it has to be a matter of record, otherwise they don't want to be responsible for it. So that being said, remember what I said a second ago, all properties have liens on them, you know, property taxes or otherwise, except maybe the Fed. Okay, so let's take a look at number 8. So said property has been declared tax defaulted for non-payment of delinquent taxes. So this is good to see. So the owner has not paid one or more of their tax liability. You would get a list here that would indicate how much that is and which ones have not been paid. Okay, you're also going to get a list, you're going to see it in a minute, you're going to get a list of what the penalties are on that. Okay, and then I'm going to show you a copy of a tax bill, which will help you to understand that as well. Okay, all right, get rid of that. Okay, so I'm buying a light. So anyway, okay, all right. So as of June the 30th of 2010, it's just been sitting there, tax defaulted for non-payment of delinquent taxes, and then amounts to redeem the above, if any. Here it is, $839, or, you know, after July 31st, $850. Supplemental assessments. So that would indicate that there was a sale that occurred. Maybe this seller is a flipper. Maybe they bought the property fairly recently, and they hadn't paid their supplemental tax. So as you know, within about 30 days after a closing, the county will catch up on things by sending a supplemental bill to the new owner saying, you know, the taxes that you were charged pro rata are going to be, you know, a little higher now because you paid a different sales price for the property. Now, if they paid a lower sales price, their tax would necessarily be less, but if they pay a higher sales price, then the taxes are going to have to be adjusted. And that's what the county does. The county makes sure that they get their due, okay? So that's going to be my supplemental tax assessment. And then again, number 10, lien of supplemental taxes, if any, are going to go in here. So an easement, so let's take a look at this, and I've got some hot buttons to tell you about here coming up in a second, because some of these things can be easy enough to see, but a lot of times we see them and we don't think anything of them. So there is an easement on this property. It's planting and maintenance, and affects the southwesterly 7 feet. Okay, so now I should have pulled up the plat map for you. I have it down at the bottom, but I don't want to go down there yet because then it'll take us a while to find our way back. But essentially it says that on the southwesterly 7 feet of the property, there is an easement for purposes of somebody coming in and maintaining it. So that would be like a common area. Or for example, if you're in Carmel Valley, the corner of Del Mar Heights Road and El Camino Real, you know, all that grassy green that touches the streets is a common area to the entire community, okay, and that is maintained separately. That's where my second HOA dues comes from in Carmel Valley, is for the purpose of taking care of that planting and maintenance. It happens in Santa Luz. I had a transaction in Santa Luz where the owner of the property, there was a maintenance agreement on the corner of the property, and they wanted to be able to put a driveway there, but you know what, you bought it subject to that easement, and now you got a petition to have it removed, and chances of doing that are going to be pretty slim. Okay, so These are the kinds of things we want to be looking for when we're doing a real estate transaction. If you see, if your client says to you, I want to put a swimming pool in that backyard, and so, can I do that? Remember, we never want to answer that question, right? We never want to say, oh yeah, sure, you can put in a pool. Look at the size of that yard, right, Maria? I never want to say that. So, but what I'm going to say is I'm going to say, well, I don't know. Let's find out, right? So when I call title, especially at this point in the game, I'm going to ask title. I'm going to tell them I want 3 things. I want you to blow up the map so I can see it. I want you to plot and color code all the easements, right? And then I plot and color code all the easements. So those are my 3 things that I want for sure. I also ask them for any copies of any recorded documents, like a notice of default or anything that's been recorded against the property, because I want to see what that looks like. Okay. All right. Who's I just looking at? Antonio, welcome. Manette, welcome. Okay. All right. So so looking at that, all properties have easements, right? They do. They have electric easements, they have utility easements, right of ingress and egress. They have things like that. So we never want to make the representation just because it's got a big lot. Can you imagine? You tell the buyer, yeah, you put in a pool. Look at it, it's got like an acre of ground back there, and then come to find out there's a huge water main running through the middle of the yard. So now if they're going to build a pool, it's going to look kind of like one of those boats, with twin sails on it. Okay, so. You don't want that bill. All right, so that's why I never make any representation. I always say, hey, that's a really good question. Let's why don't you find out and let me know what why don't you find out? Let me know what you find out. Okay. Number 12, covenants, conditions, and restrictions. Once again, pretty much every property is going to have that. But we're going to put in language that omitting any covenants or restrictions, if any, based on the protected classes. So these are the kind. I'm a practitioner like you, right? Anybody, any attorney explaining this to you is going to go into all this. Essentially, they're the protected classes, right? I mean, if you think about it, there's our federal protected classes. There are California state protected classes. The federal will always have X numbers of protected classes. California will have that plus additional ones that California might put in there. I teach the broker class in Virginia. Elderliness is a protected class in Virginia. So, it's one of those things where I'm just going to bundle it up and say the protected classes. Okay. And I think we all know what those are. Here they've given you a bunch of a list. Handicap, I thought we'd remove that. I think we say disability versus a handicap. But anyway, I'm not going to get into fair housing for right now. But anyway, it is a recorded document, January 15th of 74. You can pull that document up and see what it says. But if there is a restriction based on any of these things, they're just omitted. They're just going to be removed. We realize that there are these kinds of restrictions all over the place, right? I mean, San Diego, you should see some of the original restrictions. So we just, rather than go in and try to edit every document, we just went ahead and created one great big rule that says any reference that you make to any of the protected classes, we're just going to eliminate it. Okay. I mean, it doesn't exist. All right. And your client is taking title subject to the fact that while it might be in writing there, they also understand that it's not enforceable. It doesn't exist. Okay. We got rid of that. Okay. And it's just, if you read some of these, like what Rancho Santa Fe has and things like that, I mean, it just makes you ill. I mean, it's just amazing the kind, how sometimes we treat each other. So that being said, let's take a look at number 13 here. Easements for the purpose of, and this is what I referred to earlier, my easement for my utility company. Obviously, they need to get access to the property. They don't need you to sign a legal document every time they come on. They got to let you know you're coming, right? I mean, they're supposed to let you know they're coming, but they do have a right to come in here for poles, wires, and incidental purposes. And now we're at the northeasterly 6 feet. We're starting to wonder how much of the property do I get to use? Well, if I had the Plat Map plot and color coded all the easements, then I'm going to get a pretty good idea kind of that box that says I can work within this here. Okay. But again, you don't want to make that reference to your client. Now listen, write this down. References made to said document for full particulars. This essentially was the field case. Okay, so reference was made to this document. So the title company is saying that, listen, we're not going to print the entire document here for you, but we're going to refer to it. So whatever that document says, we're not going to insure on that. right? We're going to insure around it, okay? And so why is that dangerous? It's dangerous for your client because your client probably didn't get a copy of that. So you want to ask your title company to pull your Schedule Bs, okay? So Schedule A was the legal description of the property and how it's currently held title. Schedule Bs are all the interesting things that attach to the property, okay? So it's not going to, we're not killing trees anymore. This is just something they can go ahead and do for you as a matter of default, all right? So pull Schedule Bs, and that's what they're going to find when they see references made to said document for full particulars, all right? And again, I speak about this with attorneys, and I tell them all the time I would never do a transaction without looking at what those Schedule Bs look like. Okay, and that's where it's going to tell me, okay, well, it's northeasterly 6 feet, and so I need to know what that says. This applies not only to utility easements, it applies to other documents that we're going to see. So your title company is essentially giving you a snapshot of what's in there, but they're not showing you all of the document, okay? And so you need to be giving all of that document to your client. Do I ask for Schedule B always? John, I do. You know what? It was the third thing I was trying to think of, and I couldn't remember. So I'm going to have them blow up the plat map, plot and color code all the easements, and pull all the Schedule Bs, and then give me all the, any notices that have been supplied against the property. But pulling my Schedule Bs is they're just going to pull them all for you rather than you going through and making a legal decision. Whoops, red flag, a legal decision as to which ones they should pull. Just tell them pull all of them, okay? And when you ask them to do that, they're going to say, oh, okay, you took one of Kevin's classes, because I tell them that all the time. And listen, title people talk to me very differently than they do to normal people, as we say. But these are the things that I'm always looking for. So John, to answer your question, I always have them pull Schedule B, just part of our business model. So Linda does that. Linda, we just had a TC tell us that there was a problem with the offer, and it was like, well, I don't know, the seller's name. We were a listing agent, and I'm looking at the grant deed, and the grant deed said this is how title's held by this individual. And so they wanted to add a middle initial, but the grant deed did not have any room for that. So to answer your question, yeah, we go directly to the source. And again, in our office, we write the offers, write the listings for our agents. They get all the credit for it and everything, but we're always checking this stuff out. Linda's probably best student I ever had. She's amazing what she finds. Okay, so number 14, a deed of trust. So remember, in California, we don't do mortgages. We do loans secured by deeds of trust. Okay, so 3 parties, trustor, trustee, beneficiary. All right, in a mortgage state, they would do a mortgagor and a mortgagee. But in California, we do 3, which creates some huge advantages for the borrower. One of them is the limitations that it places on the lender's right of pursuit, so to speak. And again, this is a very general statement. If the borrower commits fraud or waste on the property, like they decided to start barbecuing in the middle of the living room floor and there's no place to barbecue, they're just going to start lighting it up. Then the bank is going to come in with a judicial foreclosure rather than a non-judicial foreclosure. But the fact of the matter is, with the deed of trust, the lender can take the property back faster, usually for non-payment, but again, they lose some recourse. And again, it's going to be different for different situations. So I would never make a blanket statement about that, okay? And I do a lot of these. We do a lot of short sales, and so we're asking a lot of questions when we're doing them as to what the liabilities of the parties are. So a deed of trust is secured indebtedness, so it's $700,000. If you're doing the transaction for $400,000, then you got to know something's not right. Okay, so it sounds like the encumbrances against the property exceed the value of the property. Then I might be looking at a short sale or something like that. It gives me the name of the owner's prior owner. I like the way they do that. That's pretty funny. And it gives me an instrument number. A notice of default filed under the terms of that said deed of trust. So remember, when there is a notice of default, and this is really important, I should have put in here Assembly Bill 1695. If somebody will remind me, send me an email and I'll put that in here so you have that in your notes. But Senate Bill 1695 became law back in 1977, and it said essentially that if the 4 prongs have to be present, if you write an offer you're under these 4 conditions and you don't give the seller their notice of a statutory right of rescission 5 days after the offer, then you're committing a crime. And so it's a year in jail, $25,000 civil penalties, criminal penalties, which means no E&O coverage, and then unspecified civil damages. And so, unfortunately, I'm involved in a lot of divorces, none of which I'm responsible for. But you know what? Divorce attorneys love it. Someone in the party is going off buying properties. So number 1, residential 1 to 4, right? My civil code properties 1 to 4. Okay. Owner is currently living in the property. Okay. Number 3, there is a notice of default filed against the property. You're looking at it right here, notice of default filed against the property. And number 4, your buyer is what the law refers to as an equity purchaser, which means they're not going to live in the property. Very loosely defined. All right. So if those 4 prongs are present, and again, if you're taking notes and you have trouble remembering that, send me an email and I'll send you the breakdown on it. Okay, but it is crime to write the offer, and there's no E&O coverage because it's a crime. Okay, so you got to give the seller their statutory notice of right of rescission, and the way we do that is we use the notice of default purchase agreement. We don't use the RPA, we use the NOD. Okay, notice of default purchase agreement. Okay, everybody good with that? So boom, I see notice of default. Remember how I said I wanted to see any recorded documents? This is a big one. Okay, so if I'm the listing agent, no harm, no foul. But if I'm the buyer's agent representing the buyer, there's maybe some liability on my part. Okay, all right, so the buyer's not going to live in the property. And I had a really bad case on that where the newlyweds were buying a property and they were going to live in the property, so there wasn't any problem. The other 3 prongs were present: residential 1 to 4, owners living in it, notice of default filed, but the newlyweds were going to live in the property, so no problem. If any one of the 4 prongs fails, the whole thing fails, and you're back to a normal offer. Problem was they brought dad in to co-make on the loan, and as a condition of co-making on the loan, the lender required dad to be on title, and dad was not going to live in the property. So it was really ugly. So if you're having problems with that, let me know, send me an email. We did a class on this a couple months ago. We might want to revisit that. Okay. But again, I'll send you the CAR has a really good Q&A on it. I was told I was given credit for writing it. It's not true. Okay. All right. Here's my number 22 for their purposes, that notice of default. Number 15, abstract of judgment. So an abstract of judgment is another thing that's going to slow or stop your transaction from recording. So if you've got an abstract of judgment against the parties, in this case, Superior Court, the name of the party was Charles Winner out of Stallion Circle, then he has a judgment against the parties for $13,512. We don't know what that is, but that's, again, always going to be the question. I wonder what that's for, right? Your owner says, well, I don't know what that is. Or then they say, oh, that's right, we had the pool put in, and we didn't like the job the guy did, so we decided not to pay him. And then so now and then he sued us, and we didn't show up, and so now there was a default judgment, and so now this is where we are, okay? So that's going to have to be paid off unless you can get the title company to waive their exception. But that's going to create a problem, right? So that's going to be a question for your friendly neighborhood title officer, okay? Tax lien for the amount shown and any other amounts due. Whoops, U.S. of America, Director of Internal Revenue. We all know the IRS, right? So there's a tax lien on the property for $5,800. That's another one that's going to be difficult to get around. Chances are pretty good it's going to have to pay. It's going to have to be paid off. And if the seller doesn't have the equity in the property to do that, then you might have some other issues you're going to have to address. Okay, but those are things that are definitely going to stop your transaction. I had one like this where I was selling a property for $65,000. Again, this is back in the early 80s. And I had to get a hold of Dennis DeConcini's office, who was the head of the House Appropriations Committee at the time, to get his intervention to get the IRS to move a little faster to remove the lien. There was $265,000 lien on a $65,000 sales price, and it wasn't going to happen, but I was able to convince them to do that. So that goes back 35 years. That's pretty scary. Okay, number 17. Doing pretty good on time here. Oh, questions. I'm sorry. No questions. Okay. Pending court action. So what do we call a pending court action? We call that a lis pendens. Okay. All right. Lis pendens, one of my favorite words. It's Latin. You don't need to know a lot of Latin in real estate, but some of the words you know, okay, that one's one we need to pay attention to. Lis pendens means lawsuit pending. Okay. So pending court action, recorded pending court action. Any attorney in their right mind is absolutely going to have that recorded. Okay. So John and Sarah want something. They're the plaintiffs against Robert and Mary as sellers persons, against Superior Court, and then for specific performance. So they're being asked to perform based on a contract. And so maybe that specific performance was an attempt to purchase this property. And now you're representing buyer number 2 and you see this in here, maybe you need to be finding out what that's all about, okay? It could very well be. Remember, you're working in a field that is very closely intertwined with the legal field, and your client at some point, don't be telling your client, we never use attorneys. You don't want to use an attorney. Listen, we have what, 26 of the best real estate attorneys in the industry in Southern California in our San Diego Association of Realtors Risk Management Committee. I refer to them all the time. So be aware, the attorneys that we deal with are there to help your deal rather than, just to get everybody in trouble. So in order to complete the report, they're looking for a statement of information. Today, they're just looking for one on all the parties. They're just going to want one from the seller. They're going to want one from the buyer. Your purchase agreement says that the parties will get it back to them within 5 days because, they need to have that information so that they can move forward with their job. Okay. John Doe, that's going to be a very common name, and that's going to be one that they're going to be asking for all kinds of stuff like birthdays and social security numbers and stuff like that. You don't want to have that information in your file. You want that information to be, handled directly between your client and escrow or title. Okay. Title being insured, trust. Okay, so now probably if you're doing real estate, you're doing any number of deals at all, you're going to find that almost half of your transactions involve a trust. Okay, so when in number 20 here, or their number 28, they're going to talk about invalidity or defects in the title of the vestees that might make it difficult for them to do the transfer of the property. Okay. And then finally, here's my statement of information from the parties below. We're going to do a whole class on trust. We're just going to have to do it because, it's a complicated subject. People come to me and they say, well, the trust doesn't have to disclose material facts affecting the value and desirability of the property. And I go, well, you got part of it right, but I don't know, they might have to do that. Only certain trusts are exempt. And so I can't give you a legal decision because I'm not an attorney. I'm certainly not a judge to say whether or not someone is exempt from the obligations to use the statutory forms. So even though maybe the trust is exempt, but that exemption means they're just exempt from having to use the TDS. They might have to instead use the ESD instead, okay? All right, let me see, end of those items. Oh, I'm doing pretty good. All right, okay. And then we get into our notations, which is the name of the buyer furnished with this application is or are John buyer, Mary buyer. We had a transaction we closed yesterday where, the day of closing, the other agent informed us that the buyer has a Mrs. who they would like to have added to the transaction. It's kind of interesting. The title didn't catch the fact that there was a Mrs. someplace that wasn't disclosed to anybody. Normally they want an interspousal grant deed or something along that line. And so now, and by the way, it's how do you want your name to appear on title? John buyer, Mary buyer. I'm going to be asking them, how are you going to sign the document when you take ownership of the property? How are you going to prove that you are John buyer? How are you going to prove that you are Mary buyer? And so I always refer them to their driver's license or something else that they had to do to prove that they were who they said they were. And then that's going to determine whether they use their middle initial, things like that. Okay. So usually you look at the DL and you can tell whether or not, how their names are going to, how they're going to want their names to appear on title, and just ask them, say, is this how you want your, title held to the property? Because that's what we're going to put in the contract. And please avoid the temptation of the veteran agent that says, well, we'll let escrow clear that up later. And it's like, I hate it when we ask escrow to clear things up later, because remember, we are the contract and we are the escrow instruction. And when escrow clears it up later, they're merely clearing it up in their mind. They're not clearing it up in the contract between the parties. Okay. All right. The Alta homeowners policy title insurance contains specific deductible amounts. This is just a disclosure of that. None of the items shown in this report, there's nothing in here that they have done that in this case Fidelity has done that would cause them to decline the issuance of a policy. Okay, so they're saying, you know, it looks okay to us. We're used to the stuff we're seeing, not a problem. But again, if it's going to be subject to the exceptions that we are going to include and we're going to have everybody sign off on, all right? None of the items cause them to decline. The company is not aware, and that's not the CIA, that's the company, which is Fidelity in this case, not aware of any matters which would cause it to decline this on the property known as 2536 Brandywine, okay, to an extended coverage loan policy. So now they're notating to the lender that they're not going to have a problem issuing the lender's title policy, which usually the buyer pays for in the transaction. There are no deeds affecting the land that have been recorded within the last 24 months. If they see a transfer within the last 24 months, like my flipper or somebody like that, then it's just going to have their ears up. Now they're going to be, you know, looking for, you know, if there's anything else going on. But if nothing's happened to this property in a couple of years, then chances are everything's settled in, everybody's fine. Property taxes for the fiscal year shown below are paid for proration purposes. So these are important numbers. Now you'll frequently see paid or unpaid. Okay, unpaid is not bad either. That just means that it's not due yet. So it might say not due, not yet payable. Okay, but if it says delinquent, that's not a good thing. When you're seeing delinquent taxes, remember again that title and escrow are going to require that the accounting be done to bring everything current. And the buyer, of course, wants to make sure that they're not, you know, taking a property that still has taxes owed against it. Okay. Another really good reason for having title insurance. We had a transaction probably about 20 years ago now with a very large company, and the buyer, the two brothers owned the property, stepbrothers owned the property together, and the one stepbrother sold their interest to the other stepbrother. Now the other stepbrother owns the property. You know, everything was cash, right? Well, the problem was no title insurance was ever looked for, no title research was ever done, and it turns out that the brother, you know, that sold their interest in the property to the stepbrother, you know, had a huge IRS tax lien which attached to the property, and so now the stepbrother ended up owning a property that had a lien that they couldn't sell the property without paying it off, and of course the other brother is gone, right? Okay, so it happens even among family, and how many of us have experienced it? Sometimes family is really the worst. Okay, so all right, that being said, let's take a look. So again, if you see delinquent, that's going to be a hot button in there. A lot of times we'll have sellers say or buyers say that the property is only worth $133,000 because they take the land value and add the improvement value. Remember that those numbers come from the county as far as what they're going to assess, how they're going to assess against the property, not the actual value of the property. Some buyers think that that's actually the appraisal, and it's not. Okay, all right. Note number 7, if property taxes are posted less than 45 days from the issuance of this policy, so, you know, then they're going to, so in other words, you sent in, you know, this happens all the time. I paid my property taxes. I sent the check in. When did you send it in? A week ago. Okay, if it's within the 45-day window, then we're going to hold that amount back and we'll give it back to you later because, you know what, we believe you, we trust you, we love you, all that. And we're going to make sure we're protecting ourselves. That's what the title company is going to do. Just like when the title company goes down there and records the document, they're going to literally, if it doesn't balance by a penny, they're going to turn around and come back to get the penny because they're not going to record the document. So that's why your escrow companies will almost always pad that transaction by a couple $100 to make sure that there isn't any missing monies or anything that's a surprise. Okay. Let's see, monthly payments for deeds of trust within 30 days of the policy, same kind of deal is going to happen. And then note number 12, RESPA. Okay, RESPA comes along, and again, remember, RESPA is an issue in transactions that involve government-insured loans. Cash, RESPA doesn't really apply. But again, I think the same principle should apply. Okay. Question, hey, Seraphine, Hispanic names have 2 last names. Yes, they do. Gonzalez Sanchez, right? Has that caused you some trouble? Should they use a hyphen? Great question. So the answer is, if there is a driver's license, it's what's on the driver's license, because the title company is going to ask the individual to prove they are. And I know you're asking a rhetorical question because you work with me, so you know the answer to this. But the title company is going to look for some proof that you are who you say you are. And if your legal name has a hyphen in it, then they're going to want to see all of that on your documentation of your name. Okay, so. Has it caused me trouble? Rarely. Most people know if they have a hyphen name or not. I haven't really had any issues with it. Strangely enough, this transaction that closed yesterday, it was like the day of closing, we find out that there's a missus. More of that. Usually there's somebody else that's going to be on title. But as far as hyphenated names, no. But good point. The Hispanic names may have 2 last names, right? Okay. All right. Good question. Thank you, Seraphine. Current owner does not qualify for the $20 discount. There was a big judgment against the title company, and everybody gets $20 credit in future transactions. And then amended civil code here, deed of trust, paying us $45, the reconveyance fee. They got to tell you about that. If a county recorder, insurance company, et cetera, et cetera, et cetera. California law requires a document provided shall include a statement regarding any unlawful restrictions. We talked about that. 14-point bold font on the first page of the document. Wiring instructions. So this is your first introduction to the wiring instruction in the real estate transaction. Our advice to you is that you use the wire fraud advisory in your transaction. Make sure your buyer and your seller sign off on the wire fraud advisory, because wire fraud is very real. All right. And so wiring instructions need to be between the escrow or title company and the principal. So the buyer or the seller. The seller may have to bring money in. The buyer is probably for sure going to bring money in. And so we need to tell our clients that they will never receive wiring instructions from us as agents. They need to deal directly with the parties. And that's why it's important to get a good title company, a good escrow company in your transaction to make sure that you're protecting not only yourself, but your client. So we just do not forward wiring instructions. And if any of your clients ever read that wire fraud advisory, they would never take a wiring instruction from us anyway. So we need to make sure the client understands that they need to be solely bound by that communication with the escrow and with the title company. Okay. All right. And by the way, if there is a case of wire fraud and somebody's money gets taken, we have a number, I can give it to you later, the FBI. If you can get to them within about 24 hours, unfortunately, it usually takes longer than that for people to get over the, oh my God, I'm so stupid. But it's like, no, stupid, get in now. And because if you get there within 24 hours, they might be able to recover the money. And so the last case that I was aware of, it was $1 million. And so that's just expensive. I don't care in whose book that is, it's a lot of money. So RESPA, again, more conversation about RESPA. And then here's my Plat Map. So I wanted to show you the Plat Map. You can see that some of these numbers are difficult to read. So remember what I said? I want you to blow up the Plat Map. Now, in the old days, they would actually send us a map that was on this huge piece of paper. But today, they can blow this up and send it to you by internet in several sections. And so it's going to be at least a lot easier to read. But like, tell me which property, which is the subject property in here? I mean, I'm looking at it and it's hard for me to delineate which one it is. Okay, I can't even read the numbers. So, that's why this is important. So where is the southerly 6 feet, that kind of thing. Okay. All right. So that Plat Map is pretty important. And by the way, don't ever, take your client and walk it, so like that looks like a 63 feet. This one's 62, this one's 62. It kind of looks like that, but you want to be really careful about going to the property and saying that's where the border is of the property, because you know what, if you're off, it's usually, you can't replace it, you can't fix it. So, okay, that's my Plat Map, and I'm looking at my clock here. Here's my Exhibit A, which are my exclusions. Notice right here, exclusions to the title policy, okay? And it goes into my CLTA policy and all that. I don't know anybody that has ever read that. Here's my Schedule B stuff, but I don't know anybody that's ever read it. I would recommend that you, at some point, if you've had a license more than 5 years, you should have read it by now. Just go through it really quick. Everybody just kind of figures that the insurance company will take care of it, but at the end of the day, they may not take care of it. So you probably should look at it. If you're going to be reading something complicated, I'd rather you read the agency disclosure form, California Civil Code 2079. So anyways, my exceptions from coverage, there's my Exhibit A's again, limitation on covered risk. Yes, guess what? They're not going to pay everything. Okay. I have people say, oh, don't worry about it. The insurance company will take care of it. I don't know. I can't quote insurance because I don't have a securities license, but this is what this is all about. Okay. Questions about any of that? I'm not going to pull up the shameless plug for Fidelity, but thank you. Questions? I know I moved pretty quickly on that. And again, I was promising myself to go a little bit slower today, but we had a lot to cover. Again, I will get you the Fields case. I just think this is a great case for you to read. You might want to spend a little bit of time doing that. And then the Strasburger case, you know, listen, we talk about this all the time. I sit in our risk management meeting and attorneys are there, you know, reasonably competent, diligent visual inspection. Gee, where have I seen that before? Oh, on the transfer disclosure statement. Oh, that's my duty, right? Oh, yeah. Okay. So those are words that when I'm having a conversation with a real estate attorney, we're saying the same thing. We could all sing it as a song if we had to. And that's where Strasburger, the Easton case, the Strasburger case. Okay. So you might want to take a look at that. Again, trying to think what was the other item I promised you I'd put. Oh yeah. The AB 1695. I'll put that in there as well. Sample of my tax bill. Let's just take a look at that really quick. Somebody says to you, I don't have Melrose. So you always want to get a copy of the tax bill. Most of your property, your natural hazard disclosure companies will provide this for you. Let me see if I can blow this up a little bit. Here's okay, good, I got a better page. So here's my copy of my tax bill. So when somebody says that there's no special assessments against the property, they are mistaken. I just don't know a property that doesn't have an assessment against it, right? So mosquito rat control, otherwise known as vector control, mosquito vector control, Torrey Highlands maintenance, Poway Melrose. Now it'll sometimes, you look at the dollar figure of that. If you get this wrong, you're paying it, right? So any transaction after October of '88 probably has Melrose on it. All right. So make sure that you're aware of that. And so this is not a little bill. All right. And so if you make it, I had a client, I was selling his property in Carmel Village right off the 56. And he says, we don't have Melrose on this. And I go, you were built in 1998. I think you do. And he goes, no, we don't. And he says, nobody ever told us about it. So I said, let's take a look at your tax bill. And there it was on their tax bill. They've been paying it all this time. They just thought it was a tax. But you can imagine what would happen if, you know, they go back after their real estate agent who says, you know, oh, I told you that there was Melrose. Listen, assume there is, okay? But when you get a bill like that, that's a big one. You want to make sure that you tell your client you probably have it. And then when you see this and it says Melrose, it'll usually say CFD, Community Facilities District, you know, that kind of thing, especially in Carmel Valley, right? Northwest, it'll say North City West Community Facilities District, because that's what it used to be called. Carmel Valley used to be North City West. Before that, it was East Del Mar, you know, and then ultimately they settled on Carmel Valley. But listen, that will bite you every single time, not to mention vector control, but that will bite you every time. Don't tell your client there's no Melrose, okay? Again, I'm just going to go thinking that maybe that's tax advice, all right? So I'm probably not going to give that advice. So any questions about any of that? That's a lot, okay? So we covered a lot of stuff, but I wanted you to at least see what that looks like on the tax report. And again, I know Property ID does it. I don't know if the other companies do it. We only use Property ID, but it's in there. It's something that's readily found. Title should send it to you, and again, Title sent this. So it gave us a sample of the tax bill. Okay, so that's really all I have for the moment. I'm right on time, which is really usually I'm 5-10 minutes over. Are there any other questions about any of that? I want to make sure everybody's good. I see people signing off already. They figure they got the lion's share of it. Questions? Seeing none, at 1 o'clock today, we will break into the buyer representation agreement again. Last week we covered commissions, my favorite subject. This week we're going to cover paragraphs number 4 through 6. So we're marching our way through the buyer representation agreement. Eric, I see your hand up. Type in a question in the Q&A field for me, will you? Thank you, Eric. But today at 1 o'clock, if you don't have the link, send me an email and I'll get that to you. Let me pull up my new share. I'm going to pull up my email address again. Here it is, kevin@burkerealestateconsultants.com. I had to create a really great big long domain name because that's what we do. We do consulting work. We do transaction management for brokerages, things like that. And then we also I do a lot of legal depositions and things like that. I love going to depositions. So Maria, oh, thank you, Maria. Thank you. It's so kind of you. You come to all these great classes. You've got to be one of the most knowledgeable people I know about real estate. But yes, I do. I look forward to seeing you at 1 o'clock. We'll be talking about that today. So thank you all for being here. And I look forward, if I can, I get to see you later. But for now, I wish you all the very best. And I hope you have a wonderful career. Take care for now.